But
So so if I'm injured in the job, um, let's start there. Let's say I have some kind of injury. We keep going back to the shoulder thing. So let's say I have a shoulder injury, and I think maybe both of us have had shoulder injuries. Maybe that's why I keep going there.
I'm anticipating Matt filing a shoulder work comp case after he's like, keep telling me about how the shoulder stuff
Oh,
works.
that's fantastic. My shoulder's feeling great, by the way. Um,
Good. Good. You
so
got to say that for the record now. I get it.
if I did have a shoulder injury at work, what would I do next? And maybe we can go from there and just kind of walk through the process from there.
Very first thing is to give your employer notice of the injury, which we've talked about. And you want to give notice as soon as possible because there are short deadlines. Generally, it's a 30-day deadline to tell your employer. I don't I don't recommend waiting 30 days because in my experience, employers get skeptical if they don't know about it right away. Not all employers, but some. Uh, so notify your employer as soon as you feel there's an injury. And it's pretty common for an employee to say, tell their supervisor, hey, my shoulder hurts. I don't know what's going on. And then the supervisor can take the lead from there. But what's supposed to happen is once you report an injury, they will file a report with the Department of Labor and they will try to determine whether you need medical treatment. If you need medical treatment, it's their job to get that for you. And so a lot of times, some of the larger employers, like Goodyear, for example, they have what they call a dispensary. I don't think they still call it a dispensary, but everyone still calls it that, where it's a medical clinic on site and they'll send you there first. Most smaller employers don't have that. They'll get you to a clinic that usually they have a designated work care clinic. If it's a major injury, let's say your shoulder gets skewered by something horrible, which of course I've seen, then they'll get you to the ER. So
So
that's the first thing is
is it,
telling your employer.
is there ever any confusion about who your direct report is, who you're supposed to be notifying, or is that usually people have a good idea about what to do there?
Yeah, usually it's just your supervisor. So the statute has some guidance on that, and I don't have it in front of me. But generally speaking, if you tell your supervisor, that's who you're supposed to tell. They're supposed to have it posted who you should tell directly, but generally supervisor.
And is like a text message sufficient?
Text message is great because then you have a copy of it.
Mhm.
But usually, as a practical matter, it's verbal first. And then I recommend you follow up with something in writing, like an email or a text message just saying, hey, I let you know about this specific shoulder injury that happened today while at work. And that's something I've seen before as far as notice goes, where an employee will say, oh, we texted about it. And then you look, and then the employer says, we never knew about this. And then you look at the text messages and they're not clear. They're just talking about, hey, I'm going to a doctor. And it doesn't say why you are going to a doctor or doesn't say that it's work related. That's not sufficient notice. You have to say, I hurt my shoulder at work and I would like medical treatment for that.
That's good.
Uh,
That's helpful.
so,
Okay, so I've hurt my shoulder and it seems like I'm really impaired. I should really see a doctor about this. Um, it- and you said they assign a doctor or they find a doctor for you.
yeah, the statute says that it is the employer's job to provide medical treatment. And so they pick an authorized treating provider. Most of the time, that's through a work care clinic. So there are occupational medicine specialists uh, that do occupational medicine. So both hospitals in Topeka have one. There's many, many work care clinics in throughout Johnson County and Wyandotte County. So it just varies on who your employer is, who their work care clinician is. So that's a general uh, facility that will offer treatment on the front end, assign out physical therapy typically. And then if frankly, if symptoms don't resolve through conservative treatment like physical therapy, then you would move on to getting an MRI, getting assigned to a shoulder specialist, typically a surgeon. In the cases that I see, that's what's typical. I'm sure there are far more cases that don't get to my desk where they get they go to work, they report it to their boss, they go to work care, they have some physical therapy, shoulder symptoms resolve, and that's it.
So let's say I've notified my boss. I need medical care. I've told them I've been waiting around for 3 months, and I still haven't gotten a doctor's appointment scheduled. What do I do now?
At that point, that is the situation where you absolutely, and you don't need to wait 3 months, but if you're just not getting anywhere, you're not getting a doctor sign, you don't have a medical appointment scheduled, and that sadly a more common situation than I wish it was. And also, we get the bad cases, right? When things aren't going right, that's when someone hires a lawyer. But if that's the situation, you should call an attorney. And what we do, our process within the work comp case, one, we file it with the Department of Labor. Two, we send what's called a 7-day demand. And three, at the end of 7 days, and 7-day demand for treatment and whatever benefit that other benefit you need. Often that's temporary total disability, which is the weekly check, which we've talked about. And at the end of 7 days, if they have not provided that benefit, you file for a preliminary hearing. That preliminary hearing, you can discuss issues like treatment, off work slips, and compensability. So those are kind of the three big issues in a preliminary hearing. Sometimes we talk about supplemental pay or temporary partial disability, which is if you're just making less because of your work injury, you can get some supplemental pay. But those are the issues that are at play. Also, payment of medical bills and medical mileage.
Why don't you
So
unpack? I don't know how much time we spent talking about these TPD and TTD. Unpack those a little bit more.
TTD is temporary total disability, and that is a check while you're off work during your treatment for an injury. So if a doctor says, there's two situations where you get it. A doctor says you are off work, and then they have to pay you 2/3 of your average weekly wage looking back 6 months. But it's not taxable. So you end up a little short, but close-ish unless you're subject to that cap that we've talked about before. So so that's TTD. So if they're not paying you that for whatever reason, you can we send a demand and then we set a hearing and we have a hearing on it. Most often we get that resolved without having to have the hearing, but not always. And the judge, the administrative law judge, you go in for usually 30-minute to an hour hearing, depending on how contentious the issues are. The judge will take testimony and decide the issues, and we'll submit medical records and evidence. And these hearings typically, like I said, are 30 minutes to an hour, but they can last a great deal of time if the case is complex. I had one that lasted 2.5 days, so it was like a trial in the sense that we had all these witnesses, all of these issues to sort out. And it was because of how many parties were involved in the accident. And so there were multiple claimants, multiple lawyers. And so it
Wow.
was a fairly unique situation. Most of the time, it's not that. So that's the preliminary hearing. And so compensability, whether the case gets paid under work comp, is often litigated on that front end at the preliminary hearing stage. It can be relitigated at the trial setting or the regular hearing setting at the end of the case, but often the issues have already been decided by a judge, so we don't have a lot of fighting over whether this case should be paid under work comp on the back end.
Cool.
Usually we know because it's been denied, and then we fight it at the preliminary hearing stage. So once you've had a preliminary hearing, you're getting all of your medical benefits. You're getting paid while you're off work. And circling back to TTD or temporary total disability, the other situation where you can get that is if a doctor just gives you temporary restrictions, then you get that uh, let then you go get or you go work within that accommodation unless your employer can't accommodate you, which happens a lot. Let's say you have a 10-pound lifting restriction, but your job is to throw 30-pound tires all the time, and they don't have any accommodated work. Then in that situation, you would go on TTD. So different employers handle that differently. Some will just say, we don't offer accommodated work. We send you to, um, we put you off. Others would rather have you there, even if you're sorting nails. I've had
Mhm.
clients do that sort of thing, and that can be frustrating for employees. But I tell them if they're going to pay you to be there, you do what they have you doing,
Yeah.
and most people are comfortable with that.
An important question before we wrap this part of the discussion up. Can the employer fire you for having filed a work comp claim?
It would be illegal for them to fire you because you filed a workers' compensation claim. Now, does that happen? Of course it does. There are bad actors in this world, and that occurs. The problem is if they fire you for another reason that is legal, that makes it very difficult because the framework is what we call the McDonnell Douglas framework, which is imported law from race discrimination cases. Uh, but so it is the terminated employee's job to say they've got what's called a prima facie case. This is actually a kind of complicated
Should
question.
we do another episode on this one,
We
actually?
could do a whole episode on that issue,
Uh-huh.
but the short answer is it is illegal. And if they do, and you can prove that it was because you filed a workers' compensation case, you have a wrongful termination case. Um, and so it is illegal to discriminate against someone. There's clear Kansas case law. It's a termination against public policy, and employers should not do that.